Good morning. Welcome to the First District Court of Appeals. We have two cases scheduled to be argued this morning. When I call your case, please stand, state your name, the party that you represent, and your readiness to proceed. The first case this morning is C-24-0567, State of Ohio versus Diana Bediako.
Good morning, Your Honor. John O'Shea on behalf of the appellant Diana Bediako.
Good morning, Your Honor. It's Ron Spring on behalf of the State of Ohio.
And I assume you're both ready to proceed.
We are.
All right, thank you. And the second case is C-24-0619, Enri ZW.
Good morning, Your Honor. Member Officer Roosevelt. Thank you.
And Darren Nye here from Mr. Jonathan Williams.
All right, thank you very much. Calling the first case C-24-0567, State versus Bediako. Mr. O'Shea, you may come forward.
Thank you, Your
Would you like to reserve any time for rebuttal?
Honor. Please, 5 minutes, Your Honor.
All right, and you may proceed when you're ready.
Thank you very much. May it please the court, counsel. I want to start by indicating, I've been walking into the Hamilton County Courthouse since June 5th, 1987, on probably an average of a daily basis, and I have never been so surprised in a decision that I've gotten than in this case. Diana was a new employee at GraceWorks. She was brand new on the job. She'd never been in trouble before. She was trained in CPR and admittedly did not perform it on Mr. Jenkins. I would submit to you that that in and of itself does not constitute abuse under the patient abuse statute beyond a reasonable doubt. Maybe it was a mistake born in panic. She explained to the police officer when she was interviewed without counsel during the 6-month period during which this was investigated as to whether or not Diana made the right immediate decision whether to perform CPR on Mr. Jenkins or not. She was interviewed without counsel and told them that she was scared, and that's why she didn't do it.
Counsel, is there anything that we can infer from that statement in terms of the necessity of her providing CPR?
You mean that whether CPR was indicated?
Yes.
No, I don't think so. And really, it gets to the crux of the matter, which is causation, okay? And there's absolutely no evidence in the record that would indicate that anything Diana did or didn't do caused Mr. Jenkins anything, whether it was harm, serious physical harm, death, anything. There's just no evidence as to causation. And therefore, I mean, whether you can infer by her saying she was scared and that's why she didn't perform CPR, I don't know really the context in which that was asked to her, but she certainly, after realizing that he was non-responsive, she went to her coworker and said, who had been there a long time before, who was also charged in this, and said, what should we do? They called the manager, who was not at the facility at the time. The manager told her to call 911. She called 911. The police arrived. And as a matter of fact, when the police arrived, the government, in its brief, uses the passive voice and says law enforcement, quote, was escorted to Mr. Jenkins' patient room. Diana escorted him. The government also described law enforcement as having removed Mr. Jenkins from the bed to the floor, quote, with the help of a GraceWorks employee. That was Diana also. Diana helped law enforcement the entire time. She followed all his commands.
Well,
But
they're
didn't
not-
law enforcement and the EMT folks immediately recognize that CPR was indicated in this case?
I don't think there's no evidence that they did it, I think, as a matter of course. There's no evidence that CPR, there was no medical testimony. There was just testimony of the law enforcement officer who, I summed it up in my cross-examination of him at page 52 and 53. And there's no medical testimony. So
But when law enforcement arrived, they performed CPR, is that
I
right?
there's no evidence as to why he did that. He said he didn't get a pulse when he got there.
But he recognized, I mean, can't we assume that he recognized conditions that would justify
I don't-
CPR?
I don't think, and I'm not being hyper-technical.
No.
I think, but when we're talking about proof beyond a reasonable doubt, I don't think you can assume that a law enforcement officer his actions would support a finding beyond a reasonable doubt that any kind of medical treatment was indicated. I think as a matter of course, when they discover someone who doesn't have a pulse, by definition dead, they do CPR. I appreciate that. But at page 52 to 53, kind of in a staccato fashion, I cross-examined him at the end of my cross-examination. He didn't know the cause of death. He didn't know if Mr. Jenkins was dead when Diana had checked on him 15 to 17 minutes after she had served him food. He didn't, quote, know if Mr. Jenkins' death could have been prevented on October 28th, no matter what the circumstances. That was my question, end quote. His answer correct. That's at page 52, lines 23 to 24. There's no evidence in the record that Diana did anything to abuse Mr. Jenkins. And there's no, most importantly, in the crux of this issue, and the Webster case that I cited at page 10 of my brief, and I argued it to the trial court also, along with other cases that pale in comparison to, I mean, I guess you could say, there's crimes of commission and there's crimes of omission, okay? This was a circumstance where, again, she didn't perform CPR, but there's nothing in the record that would show that anything she did or didn't do caused Mr. Jenkins anything. There's
Mr.
no
O'Shea.
evidence- there's-
Mr. O'Shea.
Yes.
It sounds like you might be suggesting that the state would have needed to have a medical expert. Is that accurate?
I think it certainly would have helped the state's case if they did. We don't know what we don't know what he died of.
Well, is there anything else that would have provided evidence of causation?
I think if there was an autopsy, and if he had died of congestive heart failure or a myocardial infarction, then I think maybe the failure to do CPR, there'd be a stronger nexus between that failure and the causation. But in the State versus Webster case, I understand it's a second district case, but the fact remains the reasoning is there. There's no evidence as to specifically what the abuse, what the injuries in that case, how they were caused. And therefore it was reversed, a conviction was reversed because there was lack of causation. And just to
Are you suggesting that a medical expert or this kind of medical testimony would be necessary in every patient abuse case or just this one?
Here's what I would say, okay? There's no evidence that was presented, let alone upon which a fact finder could make a finding of proof beyond a reasonable doubt that CPR was indicated, period. It wasn't there. There's no evidence that CPR would have made a difference. And as a matter of fact, the police officer testified that he didn't know if anything would have prevented Mr.
Well, does the state have that burden? I mean, does it have to prove that it would have made a difference between life and death? As I read the
No.
definition of gross neglect, it says that they have to prove that the failure results in physical harm, which
Yes.
seems much lower.
Right. Well, they have to show causation between the alleged abuse, and I would submit that under all the circumstances, a failure to do CPR does not constitute gross neglect. But be that as it may, if the court were to, if the trial court found beyond a reasonable doubt that failure to do CPR was gross neglect, then it follows that there has to be proof beyond a reasonable doubt that that gross neglect caused harm to Mr. Jenkins. And here's the crux. There's no evidence when Mr. Jenkins died. Okay, there's no evidence. So,
Well, wasn't there, didn't the officer testify that, that the patient was not cold when
he didn't say one way or the other. The report said he was. He didn't say one way or the other. I asked him that, and my recollection is He said he didn't remember if the patient was cold to the touch. The police report is why I asked him, said he was cold to the touch. But here's my point, okay? For someone to be abused, however you're going to define abuse, the alleged victim must be alive at the time of the abuse, okay? So it really doesn't, and listen, it's a horrible tragedy that this guy died, okay? But there's no proof as to when he died. And if he was dead when, at any point,
Well, don't we have to look at the evidence in the light most favorable to the state?
absolutely.
And there was a time at which he was pronounced dead, and that's defined by the record.
Well, but the police officer testified, he said he didn't know when the guy died. There's no other evidence to that effect. And he also said he didn't have a pulse when he arrived. I specifically asked him, you don't know if Mr. Jenkins was dead when Diana checked on him 15 to 17 minutes after she served him food? No.
But doesn't the record also show that EMTs continued to work on him for about 30 minutes before pronouncing him dead?
Well, yeah, but that, first of all, the fact that they were working on him doesn't mean he was alive. And again, I operate from the foundational threshold that the case has to be proved beyond a reasonable doubt. There is no,
But at this stage, we have to look at the evidence in the light most favorable to the state.
but he was dead when the police officer arrived. That's clear in the testimony. He had no pulse. That's a definition of death. He's not alive at that point. And again, there's no evidence as to what anything, as a matter of fact, like I said, I'm fine with you taking the testimony of the police officer because he conclusively testified that there's nothing there that could support a finding that Diana doing anything or not doing anything would have been sufficient to find causation beyond a reasonable doubt. There's no evidence he was alive. People die. Okay, this guy had a myriad of physical problems. And I'm not saying you discount his life because he has a myriad of physical problems. But the point is, he had a myriad of physical problems. Sometimes people just die.
And counsel, you're out of time.
Thank
Thank
you
you.
very much.
May it please the court, if I can just address the procedural matter. I know that at trial, Mr. O'Shea did ask for a stay. The trial court granted it. But in reviewing some of the docket and journal entries from which the court speaks through, there's no indication that stay was granted or with a fine or anything. But my point is I checked the clerk's website this morning. The fine has not been paid, and so I'm going to assume that this stay was granted, even it just wasn't checked on the docket, and it seems kind of disingenuous for us to make, or for us now to make that argument. So
Thank you for
address
that.
it on the merits, and because we know what happened, there was it wasn't paid and should have been granted, and it's just a check mark that wasn't there. But anyway, I think there's some pretty strong evidence to make an inference that there was some harm caused to the victim in this case. The important aspect is that when Ms. Bediako went to the patient's room, he was still alive, and she admitted to that. And then later, when she went in the room, she noticed that the patient was unresponsive and then didn't take any action.
What about the argument that he may have already been dead at that point, and therefore that any intervention would not have been useful?
That is, I think, the strongest argument that the defense has. The evidence, though, has to be taken in light most favorable to the state. And when, as you mentioned, the definition of gross neglect, we clearly know that the defendant, Ms. Bediako, did not take any life-saving measures, did not perform any CPR, did not do anything that she was certified and trained to do.
Don't we need expert medical testimony to show that her failure made a difference in this case?
Your Honor, maybe. I think that the best evidence is that you have someone who was completely unresponsive, and then there was no efforts taken to try to revive them, or there was no CPR that was performed, and then you have sort of this kind of cover-up going on too as well.
Well,
Do you need medical expert on that? That nexus where the failure of the caregiver was the result and the cause of some harm to the victim? That's a tough question.
I'm gonna focus in a little bit more on the causation piece.
Yes, that's the crux of the case.
Yes, for sure. Can you tell me what the most significant evidence is that shows that her inaction caused the patient's death?
There is no evidence unless you draw inferences that
Okay.
inaction caused death. It's not there. There isn't medical evidence there for that. The statute is, now we have to kind of parse together whether or not the statute still allows for there to be a conviction under those circumstances. And in reading it, I would argue that the intent of the legislature was that a person who is caring for a patient and they're unresponsive has a duty of care to at least take some measures to ensure that they get the appropriate treatment. As the statute says, they have to take the steps necessary to maintain the health or safety of the person. And then you have to show that when the failure results in physical harm to the person. And that's what we have here is we have to draw an inference that a person who was supposed to provide care went to the room of an unresponsive patient and didn't seek any kind of help until the third time. And all this time was passing. We had like 15 minutes at least, one the officer testified to. And so we know
Well,
that a substantial amount of time
Is that right
passed.
that she didn't seek help until the third time? I mean, as I read
Yes.
the record, the first time
Oh, I
she
read
went in was to deliver the food.
Yes.
And she didn't observe any problem then. It sounds like she followed the instructions given to her, which was to place the tray of food next to him as he was laying down. So that wouldn't have required any other action from her other than what she did. And then the second time that she went in, she noticed that some food had been eaten, not a lot of it, but some, and she thought that he was sleeping because it sounds like, tended to lay down in the prone position, and she thought he was asleep. So she didn't notice anything that would have caused her to take any other action. And then the third time when she went in is when he was unresponsive, and she alerted the supervisor and they called 911. So which instances are you suggesting that she should have taken different action?
Well, she admitted that she went into Mr. Jenkins' room and found him unresponsive and didn't do anything for 10 or 15 minutes. So I guess I counted that third one where they brought food in. So there was 10 to 15 minutes went by, and there's no help, not even a call, a consultation to a staff member for 10 or 15 minutes. And you can infer that Mr. Jenkins' condition deteriorated at that point.
how can we infer that without expert medical testimony?
Well,
I mean, what if it had been 8 minutes?
yeah,
Would that have been a
that's
good-
that's the part, Your Honor, it's hard to, you would have to defer to the trial court. It would be our argument under the statute that you just can't let 10, 15 minutes or whatever amount of time, that's a significant amount of time, elapse.
Who says it's a
before taking
significant
action.
amount of time?
I don't know. Yeah, you mean as far as a medical expert,
Right.
and because we don't know. Yeah, that's the the hard part of the case. I agree, but I would just urge the court that when this statute was written for a reason, and the purpose is to put a duty on a caregiver that if they find an unresponsive patient, that they need to at least take some measures, some steps to provide.
Like calling
some
911, would that be a measure?
Calling 911, or maybe instead of waiting for 10 or 15 minutes, immediately get a staff member or somebody to assess the situation, and we know.
So did the gross neglect begin when she, from the state's perspective, when she thought that he was asleep and then allowed 10 or 15 minutes to elapse before she checked on him again? Or did it begin when she noticed that he was unresponsive and called 911?
I would say probably she thought he was asleep and then waited, but then once he was unresponsive, she didn't do what she was trained to do. So now you're getting into gross neglect, and we know that time is valuable if somebody is not responsive, that the quicker you can get them medical treatment, the better the outcome is going to be.
What is the physical harm from the state's perspective that resulted? Because the definition of gross neglect allows for either physical harm or serious physical harm. What is the physical harm that resulted here from her failure to act?
Well, we don't know. We know that the failure to act possibly could have been the cause of death. That nexus is the difficult aspect of this case. I agree. I'm just asking a court to defer to the trier of fact, and the fact that it just took so long for there to be any help from someone who was trained and supposed to help the patient is enough to.
But I see what you're saying. I understand what you're saying, that, a person who has a duty to perform CPR or to take life-saving measures, and if they don't do it, that certainly would meet the element of the knowingly failing to provide a person with treatment or care, part of the gross neglect. But the other part of that is results in physical harm. So
Right.
even if we said, yes, CPR, she should have performed CPR. She had a duty to do so. She failed to do it. But then the other element of that is the resulting in the serious harm. So I'm struggling to understand how we can infer that.
Yeah, that's difficult, to be quite frank, because, we can sit here and say that allowing that time to elapse, that this was clearly, there should have been some help given to the patient earlier. But now we have to show that that delay caused physical harm. And when you have a deceased patient, we can infer, we may think that caused, contributed to Mr. Jenkins' death, unfortunately. But yes, that's difficult. You need that medical evidence and somebody to come in and testify there is a nexus between that delay and that physical harm. I would just say that you can infer it because common sense would say that any time there is a significant delay in getting an unresponsive person treatment, there has to be some resulting harm to the victim.
And how is significant defined?
A significant delay, well.
8 versus 10 minutes, is
I
that
would
significant?
look at the statute imposing the duty on the patient to provide the appropriate care that they were trained to do, or the employee to provide the appropriate care that they were trained to do. And so here, we know without a doubt, that's not really an issue, that CPR was not performed. Bediako did not promptly seek any type of assistance or perform CPR to an unresponsive patient. So we know clearly there was gross neglect there. And since we know that the result ended in the patient's death, you can make an inference because we all know that the failure to perform life-saving measures or to attend to the care of an unresponsive patient, that delay is going to, is crucial. I mean, we know that by a matter of common sense, that delay is crucial. But I understand the questions. But I would ask that the court find what the judge did. The judge was the trier of fact. I think the judge made the decision based upon the fact that there clearly was gross neglect and not seeking immediate care that the defendant was trained to do. And we know that resulted in the death of the patient, or that contributed to the death of the patient, because we know how important getting care in a timely manner is. But that's all. Thank you.
Thank you very
Thank you.
much.
Do I need to address the mootness argument after Ron?
We don't have any questions.
Okay, great. Judge Kinsley, I think you hit the nail on the head when you said, quote, might have already been dead when she went in and saw him non-responsive. Without evidence to the contrary, I'd submit that there's insufficient evidence to support the conviction, even taking the evidence in a light most favorable, because there's none. And it's against the manifest weight of the evidence, because it would result in a manifest miscarriage of justice to sustain the conviction. I mentioned State versus Webster. The court, and in my brief at page 10, the court concluded that because there was no proof that defendants' alleged negligent acts were the actual cause of the injury suffered by the victim, defendant's conviction was based on insufficient evidence, even in a light most favorable to the government. As noted, by the court, quote, the state presented no evidence that any delay by Webster in seeking treatment or care for the victim's injuries resulted in the physical harm at issue warranting reversal for insufficient evidence. I know it's a second district court case, but it explains everything that is in this case.
What about the argument that this is just a simple inference that we can make, that CPR wasn't performed and he passed away? Can we infer something from that?
I don't think you can. As I think about it, I think we don't even know what he died of. I mean, if he could have died of a pulmonary embolism where CPR wouldn't have done anything. He could have died of a stroke. He could have been on his lap. I mean, he's laying there on his face down when she came to see him. He could have had the flu and died of that. My whole point.
Wasn't he examined just a few days earlier?
Well, what?
Didn't he go to the doctor just a few days earlier and they found that he was healthy? Well, relatively, for his condition.
Quite frankly, they did say he was healthy. That's absurd. And that was in the report that was generated over the 6 months that it took them to come to the conclusion that Diana in an instant didn't act appropriately. I mean, we've been debating what happened on September 11, 2001 till now. And these people had to make split-second decisions. Diana had to make a split-second decision. And it comes back to this. It distills down to this. There is zero evidence of causation. That's what the second district saw in that case, and that's what the deal is in this case.
Was there an autopsy performed on the patient? That's not in the record, right?
It's not in the record,
Yes.
and I honestly don't remember.
Okay, thank you.
Quite frankly, I was prepared to cross-examine a medical expert that they never brought. And again, I forget about this. I don't have to prove anything. They have to prove the case beyond a reasonable doubt. And if they don't, then she needs to be found not guilty. And it was a miscarriage of justice that needs to be corrected by this court when she was found guilty. If you look at the entire record, that's the standard for a manifest weight of the evidence. And the second district, again, in a case almost identical, said there was insufficient evidence because there was none on causation. And that's what this thing distills down to. And therefore, the conviction needs to be reversed and Diana needs to be ordered discharged. Thank you very much.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. The second case on our docket this morning is C-24-0619 and ZW.
Is my client allowed to come up and sit next to me?
Yes.
Thank you.
And as a reminder to both parties in this case, please avoid saying the name of the minor child. Mr.
I have a little trouble hearing, I did not get that.
Avoid saying the name of the minor child.
Oh, very well.
Thank you. And Mr. Haas, you may come forward when you're ready.
Thank you, Judge.
Would you like to reserve time for rebuttal?
May I please?
How many minutes?
5 minutes max.
All right.
First of all, I want to thank the court and counsel. It's always an honor and a pleasure to appear and try and demonstrate what we learned in law school. The history of this case is that father filed for custody. Mother hired an attorney. Father hired an attorney after he had filed pro se for the custody. This matter went before a magistrate, and you have, and I know you have, read the transcript of what happened as the two attorneys introduced their positions to the magistrate. So I wish I had one of those things where you could hang the petition for custody in the air and you see that, and then hang in the air that the two attorneys, in explaining where they were going with this case, said the following out of the transcript. Mr. Nye says, so we would contend that's what he suggested as a shared parenting plan should be followed at some level. I think he deserves to have somewhat comparable or equal time with mother, and that's not taking anything away from mother or wanting to take anything away from her, but allow him to be a full-time father. Just like she's mother, be equal in that capacity. Mr. Nober, when he's given an opportunity, and that's page 185, line 20, Your Honor, a lot of what Mr. Nye says, we do not disagree with. I think father should have a lot of time with his daughter, maybe not quite 50-50, because of it is his employment situation. My client would still like to have more than 50%. That being said, given a lot of the concepts of shared parenting, I think the parents can work together and agree on all major decisions. He goes on. So now up here in the air, we have father's attorney, mother's attorney, essentially saying, let's work on the plan that father drew up and provides to the magistrate.
So, reading the judgment here, I believe the court indicated that, and I don't know what page of the transcript this is, that father proposed shared parenting, but he indicated under oath that he felt it would be best if he were granted custody. And mother likewise expressed concerns about shared parenting due to her perception that father has control issues. So, assuming that that is accurate,
That
isn't...
is directly out of the transcript, yes.
Yes, so isn't that both parents saying that shared parenting wouldn't work?
Not my interpretation, okay? I think they're just, mother does not want to give up that custody position, period, okay? But when there's a shared parenting agreement, and that's the crux of Mr. Nober, okay? And you now have the lay of the land, so to speak, and the decision was made, and then Her Honor, the Graffenried made a decision, and you have that decision in front of you. And in there, she says, as he or mother's obviously upset by the decision, that's from the magistrate, however, being unprepared for father to be awarded custody is irrelevant. to the best interest of the child. So then that brings us to the difference in the status of the law here between the state of Ohio saying we want the children and we want to divest the parents who are bad parents of custody, okay? And in that
This isn't a parental termination case, right? I mean.
Correct, yes, okay. And I understand counsel's argument that maybe Mr. Haas is trying to pull in some fairness from that decision into the status in this case, and I'd like to have a minute to discuss that. When the state of Ohio takes a child, or some agency of the state of Ohio, the parents are permitted to appeal that decision and make a claim for ineffectiveness of counsel. That's in the case, okay? Now, the analysis here is that this case started somewhere in May of last year, and my client does not have custody of her child. How is that different?
Well, I mean, the difference is a termination case that completely severs all ties. There are no residual rights whatsoever. But in a custody case such as this, the parent hasn't permanently lost custody of the child. So, I mean,
Well-
and also, there's a lot of case law stating that there is no right to counsel in a private custody matter.
Well, I don't disagree, and that's why I'm asking this court to think broader, because the fact is, today, she sits with no custody, okay? So what I'm saying to you is this, okay? And it's kind of interesting, it's a little on track with well, if this were a criminal case before you, misdemeanor of the first degree, you may raise the issue of ineffectiveness of counsel. If this is a state taking a child from a parent permanently, you may raise ineffectiveness of counsel. So does that mean that the state of Ohio, in the case law and the situation, it says, well, she just lost custody, but it's not a really big deal, and she can't claim ineffectiveness of counsel? This was the worst performance by an attorney on behalf of his client in a situation like this that I've ever seen. If this had happened in a misdemeanor over there on the first floor of the courthouse, Your Honor, the defendant could raise the issue of ineffectiveness of counsel. And here's
And
the
was
other
this
thing.
issue of ineffective assistance raised below?
Pardon me?
Was it raised below? the
I
question of
raised it,
Ineffective
okay,
assistance?
in front of Magistrate Heber, didn't come up, I wasn't there. I raised it when I appealed her decision, and that's when Judge DeGraffenreid read the statements, the affidavit that Mr. Nobler made, and say, I thought I was there for a 50-50 custody battle. That's what we were talking about. That's what we argued about. That's what they both, Darren and I and Mr. Nobler were the attorneys in that room, and they were talking about the shared parenting a proposal filed by Mr. Williams. I agree. He filed pro se custody. The magistrate went with it. The judge went with it. Now, am I here standing enlarging, saying that perhaps the magistrate and the judge got it wrong? I don't think that's the case, but I don't think it helped the situation, Your Honor. And here, going back to my misdemeanor, when that misdemeanor is found to be guilty, he can wait out his time. He doesn't go to prison. He doesn't he doesn't go to jail. Nothing happens, and a year later or 6 months later, it's off of his record. My client is still suffering because her attorney, in his own words, says, I was unprepared and I didn't know what I was doing in there. And that is a
Isn't the
miscarriage.
remedy for that a malpractice action?
Well, that's exactly the question I was hoping you were going to ask, okay? In a malpractice case, okay, and their brief says this is a civil case, okay? I'm in the middle of a half a dozen in my career. It's about money, it's about a house, it's about a horse, it's about something, okay, that's got a monetary value normally, or it has a defamation issue or something like that, and then you get an apology and I was wrong or whatever. We cannot give my client back at this time the time she has lost with her child since May of last year. How do we do that? How do we do that? If for example, one day with the minor is $1, can you order that dollar returned? Is that going to make a difference? No.
So you're advocating for us to basically change the law here?
Broaden. Understand that she does not have a remedy the way the law is constructed today that puts her on equal footing with somebody who sued somebody for loss of a horse.
Are you suggesting that case law, the overwhelming body of case law that says that parents in general custody cases don't have a right to counsel, that body of case law didn't take into account the exact interest that you're talking about?
Exactly, Your Honor.
Do you have any evidence to support that? Can you point me to anything in case law that would suggest that courts deciding that parents in simple custody proceedings don't have a right to counsel, that those cases didn't take these interests into account?
Candidly, no.
Okay. Your time is up if you
Thank
want to
you.
reserve 5 minutes.
Appreciate
Thank you.
Fit Police Court. Darren Nye for Mr. Williams. I'm certainly asking you not to broaden this law that Mr. Haas talks about. There certainly shouldn't be, and I think the case law is very clear. We'd cited In Re LA out of the 3rd District that I think follows it very clearly as to why there shouldn't be ineffective assistance of counsel in a private custody case. And I would go so far to say is I don't believe there was ineffective assistance of counsel. If you look at the end result, the magistrate went through 3904 very clearly, boilerplate, took the statute, put it in her entry, and went through and addressed each issue in there. And she did it adequately, took the evidence that was presented, and explained exactly why she was giving my client custody.
What did the parties believe that they were going to trial on?
I don't know what was in Ms. Miller's mind, okay, because I represent Mr. Williams. I know he had initially filed a petition for custody or shared parenting. And as we had noted in our objection with the judge, is basically when you go to trial, everything's on the table. I mean, I've had many times where there's been what I would consider a pretty good plea offer in a criminal case, and you choose not to take it, and at the end, you don't get to come back and say, oh, well, we don't want 8 years. They had offered us 2 in negotiations, and we chose not to take it. We went to trial because we did not want that.
Was this a trial about the details of the shared parenting agreement, like who was going to have what holidays or something like that? Or was this a trial about sort of the general family issues between these parents?
The general family issues between the parents. And if you look at the record, my client, both parents presented what I consider reasonable testimony from different witnesses. I don't know if Ms. Miller presented any other witnesses, but she certainly testified herself and explained why she wanted what she wanted. I believe that there's a notation in the where Mr. Nobler indicates my client would prefer to have custody. Okay, well, you know, that's her wanting custody, and my client wanting custody is the alternative, or the magistrate deciding shared parenting was in the child's best interest. And the magistrate decided that it wasn't in the child's best interest, though she still gave mother 50% of the time, which I think was very fair.
You just answered my question. I wanted to clarify that about how the parents did have, the end result is, although your client has legal custody, the parents have shared time, correct? Equal time?
That is correct. So when Mr. Haas says somehow mother is at a loss, she's not. My client's equal with time, which is what it, in my personal opinion, if it's in the child's best interest, is what it should be. Now,
Okay,
there's
next-
times where it shouldn't be.
Next question. The motion that gave rise to this hearing, this trial. It was a motion for alternatively shared parenting or custody, correct?
Correct. And I did, that, I wasn't part of that filing, but yes, that is what the boilerplate motion is that's filed.
Okay, thank you.
So I certainly believe that the magistrate made the right choice because she went through and there were a number of things that mother had done that were disturbing to the magistrate. The mother told my client that the child was going to school at Our Lady of Grace, and when my client went down there to check in with the principal and be involved and do the things that you would expect a parent to do, whether they have custody or not, he finds out that the child's not registered there for school. There were a number of instances like that that was a concern to the magistrate, which is why she said, I'm not going to give you custody, ma'am. I'm not going to do shared parenting. I'm going to give him custody, but you're still going to have a large part of this child's life. Because this wasn't a newborn. This was I think she was 5 years old when this petition started. So prior to that, the parties, and there's lengthy testimony about what went wrong and the weaponizing the child and whether or not payments were being made because there wasn't a child support order until my client went down and filed for child support in this petition for custody and shared parenting. So those are the reasons why the magistrate made the decision she did, but.
And doesn't the law compel the juvenile court down that pathway? I mean, the juvenile court initially has to make a determination if shared parenting is in the child's best interest, and if it isn't, then the juvenile court has to make a custodial determination.
Absolutely, Your Honor, because in Ohio, initially, the mother is the legal custodian until a court makes a determination otherwise, and then it's just a best interest standard, and they weigh that out, which is exactly what the magistrate did. I think that the hook that Mother and Mr. Haas are hanging their hat on, the ineffective assistance of counsel, is just not there. One, I don't think it applies in any which way or form. And I don't think that Mr. Nobler, however he handled his case, fell below the objective standard of reasonable representation. But then there's another piece of that, which is then, you must prove that the result of the trial would have been different. And I don't, even if you get past that first piece and somehow you broaden the law to allow for ineffective assistance of counsel, I don't think the end result would have been any different. The magistrate made a very well thought out decision. She went through. I've seen some horrible decisions in my day where, there's just not a lot of meat to them. There's not a lot of law to them. There's not a lot of case law to them. This wasn't it. It laid out everything exactly like you would expect.
Was this even raised below? I know Mother filed some handwritten objections that were more kind of factual or evidentiary. And then there was a supplemental objection that was filed with the affidavits. And that seems very focused on kind of the process, and that shared parenting was expected to be the topic of the trial. I didn't see the words ineffective assistance of counsel in that supplemental objection at all. Do you recall whether that was raised below?
I don't recall, Your Honor. I know that it's been an underlying theme, but I don't know if it was in the record or if it's just my discussions with Mr. Haas at different times.
Thank you.
So we would certainly contend that when you look at what's been presented and the only argument that Mother's made in her appeal, that it doesn't go there. There isn't an effective assistance of counsel. The matter was decided properly. Ineffective assistance of counsel doesn't apply, and custody should remain with my client. And if there's some issue down the road, if there's a change in circumstances, then you have that opportunity to do that and come back to court. This isn't a permanent custody case like Honorable Judge Bach had indicated. Mother still has the avenue to go back to court if there's a problem. She can go back to court and argue as to why there should be a change in the allocation of time. All of those things are still available for her. She's lost really nothing except for the fact that she is no longer the legal custodian. And the reason that happened is because when she had control, there were problems. The magistrate noted those and said, this is how we're going to resolve it. We're going to resolve it by making my client the legal custodian, because I believe he will be the one that will more appropriately convey what's been asked of this court and its orders, and that's in the child's best interest. So that's what we stand on, Your Honors, if there's no other questions.
Thank you.
getting the feeling, panel, that you're all trying to help me and shepherd me perhaps away from the argument of ineffectiveness of counsel, leaving it there, but moving more closely to what the parties were doing in front of the magistrate. And I just want to take a second here, a minute, and direct the court to page 76, lines 10 through 25, which is Mr. Nye questioning his client, Mr. Williams. Is that the proposed shared parenting plan that you're asking this court to adopt? Answer, yes. Next question. Okay, what are you suggesting? Have you looked through, is this standard plan, or is this something that you looked through that you specifically made recommendations in the plan because you think it will, you want those recommendations? Answer, Mr. Williams, I've been doing a lot of research, doing what's best for my child, a lot of things I didn't know until I got into this situation. I want to look at what's best for my child at her age, When I get upset on how I've been treated, I want full custody because I can. I can delegate and be civil. When I look at Shamika and me having a daughter, I want her to have her mother in her life. It's her mother. When you say full custody, you don't want mom to have custody, you want to have custody, or you want shared parenting where you guys are equal? Well, to be fair, 50-50 is, I'm sorry, that's the answer. Well, to be fair, 50-50 is fair. Question, okay. And that would be.
Isn't that what happened here essentially? I mean, do you admit that mom has 50% of the time?
I'd like to answer that, but I think critically the last exchange, okay, Mr. Nye says, that would be each of you being custodian. I'd like that to set in, okay? That's the lay of the land. That's what's happening in front of the magistrate. That's like the example that was used by Mr. Nye when he says, well, you get a deal and you don't take it. Well, this is different, okay? You're charged with murder and everybody's arguing manslaughter. Well, murder's off the table then, okay? The lawyers.
Let me push back just a little bit on that.
Yes, Your Honor.
So the magistrate or the juvenile court or any court does not have to necessarily take either party's position in a legal custody case. Rather, any magistrate or judge deciding legal custody has to consider the best interest of the child. So let's say that both parents said, we want shared parenting, but the magistrate or judge decided that is not in this child's best interest because of A, B, C, and D.
And my response to you is this, that I don't believe, first of all, what's really interesting, you ask about what happens in juvenile court and these type of cases. Nowhere is the record show that the court interviewed the child as to what the child would want, which is like, that was I didn't even put this in there, but that is a definite, serious error on part.
Well, isn't this a very young child?
She was 5 at the time, Your Honor. Okay. Eloquent, personable, bright, and knows what she wants.
Now,
Elastic-
counsel, your appeal is based on ineffective assistance, correct?
That's right, Your Honor.
And I believe when you were up the first time, you conceded that under the current state of the law, you can't bring a claim for ineffective under these circumstances.
You're actually, you are accurate. I didn't want to say actually. You are accurate, Your Honor.
Okay, thank you.
Thank you. Anything else? All right, but thank you so much for your attendance and your paying attention to this. Thank you.
Thank you very much. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.